You brought a lawsuit against your careless doctor, and now you are in the middle of your trial. During the middle of the trial, the judge makes a ruling that you personally disagree with. Can you jump up out of your seat and yell out, "Judge, that's outrageous. How can you not allow this evidence in?" Can you do that? You want to know the answer? Come join me for a walk near the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The short answer is, no, you can't do that. If you were to do that in the middle of your trial, the judge is going to call you out and start yelling at you, screaming at you, telling you to sit down. Sit down and be quiet. Why? Because your job as the litigant, as the person who is bringing this lawsuit, is not for you to shout out your opinions about whether the judge is or isn't correct in his legal ruling. That is not your function. Everybody in court has a certain function. The judge gets to make legal rulings. The judge gets to decide scheduling. The judge decides what witnesses will and will not testify. The judge decides whether certain photographs will come into evidence and the jury will be allowed to see it. Everybody has a place in that courtroom. Your lawyer is known as the plaintiff's attorney. He has a function. His function is to present all the testimony and evidence to put your best case forward so that he can make out what we call a prima facie case. And what is that? It means he has put forth all the evidence necessary to meet all the elements to make out a case so that ultimately a jury will be able to decide whether or not you are right. If you are unable to meet all the necessary elements for a particular case, let's say it's a medical malpractice case, then before you even get to the jury, the judge will likely throw your case out. The defense attorney has a job to do as well. His job is to go ahead and defend his client or clients to the best of his ability. Now, the court officer has a job. Everybody in the courtroom has a job. Your job is to sit and listen to the evidence, to sit and listen to the testimony. When you get up to testify, your attorney will spend a great deal of time and effort questioning you in your own words about what it is that happened to you and what injuries you suffered as a result of that wrongdoing. The defense lawyer will have an opportunity to cross-examine you. Now, there will be times, maybe even many times, where you disagree with something that's going on during the course of trial. Maybe you think the defense attorney is doing something underhanded. Maybe you think certain evidence should not be presented. Maybe you think a witness on the witness stand is lying through their teeth, and you want to voice your opinion about what you think. You want to stand up and yell out to the entire courtroom, "He's a liar, Judge!" And you think that by doing that, that's going to change the opinion of the jury. Well, I have to share something with you. As much as you want to do that, as much as you feel that that will be great for you in your case, just the opposite is true. The jury will look at you and wonder why you're screaming out. The jury doesn't know the details of your case as well as you do. They don't know what is or is not true. All they know is what's put before them. The evidence, the testimony, the witnesses. And now they ultimately will have to make a decision for themselves as to who is more believable, who is more credible. They don't know yet why you're so upset. They don't know yet why you're screaming and yelling. And just because you are screaming out, that's going to appear to them, that's going to give them the perception that you are somehow, in some way, in some fashion, unstable. And now you are prone to having your buttons pushed very easily. And that's going to call into question your credibility and your judgment. So by jumping up out of your seat and yelling out, "Judge, he's a liar! Don't believe him!" You might think, yes, that's going to help the jury understand your particular case, when in fact, just the opposite is true. So why do I share this quick information with you? I share it with you just to open your eyes and help you understand how these types of medical malpractice cases, these accident cases, and even these wrongful death cases work in the state of New York. You know, I recognize you're likely watching this because you have questions or concerns about your matter. Well, if your matter happened in New York, but you have not yet started a lawsuit and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a wonderful day.